From item number 14 to 23.
You would like to mention item 19, my lord.
Item number
19, my lord. The concerned CDC lord is having a bereavement, in the family, my lord, today. Where is it?
item number 19.
My lord.
You're for the
Yes,
appellant.
yes, but I am for the appellant.
You're for the appellant.
Yes, sir. For the respondent, my lord.
As prayed for on behalf of the respondent. Let this matter come up. On your date in May.
11 May.
May I please, Lordship? Lordship, I beg to mention item number 24 and 25, Lordship, with the consent of the other party, Lordship. Lordship, this
Yes.
met,
Circulated. All right. Sometimes in
connected matter, Lordship.
No, you want adjournment in 22, 23.
24 and 35, yes, Lordship.
24,
He's asking for 24, 25.
also along with 24.
Along with 24.
The 2022 is not there. This is by order.
What do you want?
Adjournment, Lordship.
No. Let it be called out first.
Lordship, this matter is fixed on 27 April, Lordship, as for the last order, Lordship.
Somebody had mentioned for
I can play it too.
placing some facts by through alia. Let us see, let it be called out. In case it is found that there's no problem in adjourning the matter to 27.
Lordship, my senior is out of station, Lordship.
That's all right. So can you wait? Can you not wait till 22nd, till we reach 22nd and 23rd?
Lordship, humbly obliged, humbly obliged, Lord.
From item 26 to 35.
Yes.
To mention item 29 on behalf of respondent, my lord.
But why do you stand there if you have to
No, no.
argue to the respondent? Mr. Das. Mr. Yeah. Mr. Gupta, your prayer is refused. Every time you create confusion. What do you want?
My lord, in item 29, my lord, an
Wait for the
affidavit was to be filed, my lord.
wait for the matter to be taken.
No.
Don't stand at a place which is not slotted for you.
My lord.
Let's see when the matter is called out.
May I please, Lordship? In respect to item number 30, Lordship, we have circulated the items.
Yes. All right. May.
35.
15 May.
What should be in regards to item 32, 30, 30. What should be in regards to item 32, National sleep has been circulated.
Which matter?
What should be item 32?
Adjournment slip there. All right.
No, Lordship.
9 June.
With the consent of the other side, Your Lordship, I'd like to mention item number 36, Your Lordship. Lordship may kindly adjourn the matter for today and list it in next week, Your Lordship.
Item number 36.
Yes.
This 36. What do you want?
Adjournment, Your Lordship. Lordship may kindly take up the matter next week, Your Lordship.
As you're for the appellant.
Appellant, Your Lordship.
All right. Yes. Any objection, Mr. Mohan?
No, no, my lord, I am not, Lord, I am not in this matter.
Okay. As prayed for on behalf of the appellant. Have you taken consent of the
Yes, Your Lordship.
as prayed for on behalf of the appellant? Let this matter come up. Happy to.
Public.
My
Yes.
lord, I missed the item number
24
18
April.
mentioning time, my lord. Item number 18, my lord. My lord, may I pray for a little accommodation, my lord? Next.
Mr. Boyan, this is an advertisement of 2000.
My lord is already hard, my lord. My lord is already hard, my lord.
Haven't we heard and disclosed our mind?
My lord,
Why do you want to keep this?
Lord, one last occasion, my lord, some development is there, my lord.
That's great for next time. Please don't ask.
No, no, my lord, I will not take adjournment, my lord. This is the last
Why
time
don't
I.
you withdraw this petition? Certainly, you heard, we dictated also.
My lord,
I think we have dictated major part of the order.
my lord.
And we have also said that at this
Not
stage,
actually,
Mr. Bhuyan insists.
not actually, I was ready to argue, but the some instruction from the client, my lord, that's why. my lord.
I'm keeping it in the. As prayed for on behalf of the appellant, re-notify me.
My lord, I
25
beg to
five.
mention, my lord, another item, my lord, for listing, my lord, that Qazi matters, my lord, that has not been,
Which matter?
the Assam Muslim marriage, the new registration law is under
Qazi.
challenge, Qazi's matter. My lordship has already heard, my lord. My lord, can it be taken up on next week or any other date, my lord, maybe please?
We'll observe you for a week. If you don't seek any adjournment in the matter, we will uplist your matter in another.
My lord, my lord,
We'll observe you for a week.
my
You
lord.
take time and then you ask for.
No, no, my lord, in
Some
that,
matter to be
in that
listed.
matter, my lord, we
So-
will not, my lord.
Make a mention next week. After you will hear you.
My lord.
But in the meantime, there should not be any mentioning from your side for adjournment.
No,
Then
no,
only
no.
we shall accede to you. All right.
My lord, obliged, my lord.
Any other request?
Beg to give up. My lord, I'm making a prayer for listing IA, my lord. My lord, my requisition was allowed. Now the Union of India has filed a delay condemnation petition. And the guard of this pendency of this, my lord, IA, they are not complying. And it was last listed on 7/3/2025.
No, so you file your you must be on caveat.
No, I have not been given. I received a notice there that,
So you appear there.
yeah, I
You
let
must
them,
have fixed a date,
Lordship will just listing, I filed a.
not at your instance.
Any date
fix in the IA?
No, my lord.
How can it be? If you issue notice, we fix a date.
No, it was last listed on 7/3/2025. Thereafter it is not been discussed.
7/3. Okay. Make a mention, file a slip,
Yes, I,
file a slip, we'll see, not at your instance.
my lord, I have.
Ever since 21st of July, all matters are dated
Yes, yes.
in a journal.
Nowadays it is dated, my lord, but in this case,
Inform the other side, inform the state that you are making a mention for it to be listed.
yes, sir, right.
Take their consent and we shall have it listed. Do it today, mention tomorrow, we shall have it listed.
Yes. Deeply.
Daily list for item 1.
3:30 days.
Here, madam, that's the affidavit has been filed today, yesterday, madam.
You have filed.
Yes, madam.
Have you given the certificate that you filed Dasti?
How or not?
Yesterday it was filed, madam.
Huh?
Yesterday it was filed, madam.
You have filed, what is your statement that whether you have served or?
Yes, sir, sir.
What is already up?
It appears that Dasti notice has already been served on respondent. Number?
Sole respondent, madam, class number 1.
Respondent. Awaiting his appearance in the matter to contest this case, the matter is adjourned.
Obliged.
6 May. Item 2.
Completed, that's the file क्या on one and two.
Awaiting the appearance of response number 1 to 4, who have already been served Dasti to appear and contest, for contesting this case. The matter is adjourned to 2 weeks. If they don't come, we pass an order.
Most of them.
29 April. Item 3.
Lordship, a similar affidavit has been filed by us on 23rd of March. It should be on record. We have done the necessary paper publication in the matter.
Substituted service of notice. Paper publication has already been made for the appearance of the respondent. Today, nobody has appeared on behalf of the respondent. Awaiting their appearance in this matter. This is a.
8 May.
Deeply obliged.
Item 4.
7.21 days delay.
Color occasion, मला council of the opinion has not appeared. मला कांदीची case आहे, ते मला 5 minutes.
Nobody appears on behalf of the applicants today. On the earlier occasion also, that is on 5/2/2026, nobody has had appeared. You are Mr. Patgiri, Mr. K.R. Patgiri, learned advocate from the respondent. This application is discussed for non-enforcement.
Obliged. Item 5.
May please allow. The lordship should kindly come to me, Lord. Page number 15 of IA 3317.
No, have you passed any order in this? Okay.
Notice is provided to the requirement.
Just a minute. But what is this forum of filing interlocutory application bringing to the notice? Mr. Chaudhary, if at all you have some complaints with respect to breach of the order passed in any case, this is not the forum, no? You bring it on record for what purpose?
No, my Lord,
We accept it.
I think it is too serious a matter to be ignored.
No.
With all sense of
But
responsibility,
what did we
well,
do?
that forum, I'll come to that forum part. Kindly see, my Lord. Law officer of the state appears, makes a statement, they files an affidavit.
You have to tell us, there is no order of mine in the record, therefore I don't know what are the facts.
Now, if a lordship should kindly come to page 15 of the IA.
No, any order that we have passed.
Earlier.
Yes, earlier, I'm referring to earlier order of this honorable court only. The order is dated 13/11/24. It starts at page 14. Please come to page 15, my Lord. My Lord, the order starts at page 13.
Yes.
Please come to page 15. The deponent states on top at page 15. The deponent states,
Page 15 of the.
I am,
Of the IEA.
an order which was passed by this honorable court. On oath, these statements were made, my Lord.
Yes, what is it?
That the deponent states that the matter was taken up at the highest level, and accordingly on 5/11/24, the Honorable Chief Minister Assam has announced about realignment of the proposed flyover without affecting the two sides of the Divulipukuri pond and the trees standing thereon. Now, this is important. As per the proposal, the design of the flyover has been modified, and now one side of the bridge will start from Lamb Road Point at GNB Road, and other side will start at GNB Road near Ravindra Bhavan Point. Resulting both the banks of the Divulipukuri and the tree will not be affected in any manner whatsoever. The realignment of the flyover has been decided, and necessary survey and preparatory works are going on for the new design, and the same is not yet finalized. It is pertinent to reiterate in most categorical terms that not a single tree on the bank of Divulipukuri will be affected under the modified design of alignment of the proposed flyover in question. Now kindly come to the last paragraph, my lord. Needless to say, that if in future the petitioner or any other vigilant citizen feels that the stand taken in the affidavit by the state is not adhered to, he or she may be free to approach this court by an appropriate proceeding. With the above observation, now what had happened, my lord? Earlier, the original proposal was the flyover would cover also the area of abutting the Divulipukuri tank, my lord.
That's all right. Now, what do you?
Now, my lord, now, according to the statement made on oath, one side of the flyover would end on Lamb Road and other would end on Milord Robindra Bhavan. Now, Milord, that portion which was supposed to end on Robindra Bhavan, now they have extended it by 550 meter, feet.
Thereby doing what? Thereby.
Thereby reneging from the statement made on oath before this honorable court.
That's all right. But the extension is for the gradient, soft gradient. Now, has it caused any
No,
felling
Milord,
of trees?
it is not a question of gradient or anything. They say one side of the flyover would end on Lamb Road and one side would end on Robindra Bhavan. Now the flyover is extended up to Milord District Library, the road which is just in front of the High Court. And Honorable Justice Arun Dev Chaudhary knows it very well, Milord, what is the locations and all.
We remember some litigation here where the Lamb Road and the District Library.
Actually, Milord, initially it all started with felling of trees.
So we have.
Because there is no statute, no SOP, state of Assam do not have. Now, to the extent of the undertaking, they began with the High Court, that there will be no felling of trees on the either side of the Difilipuri tank. To that extent, it is okay. But going by the statement, affidavit statement made on oath, the other side of the flyover should have ended on Robindra Bhavan point. Now it has traveled by another 550 feet. Lord, this is a very serious matter, Milord.
That's right. We understand the seriousness of it, Mr. Chaudhary, but what I'm trying to understand is something different. I mean, here my question, answer me, it is a serious matter, of course. But then seriousness, I would appreciate only if I'm satisfied, no, when you give me the inputs.
I'll try to satisfy your lordship, Milord, if the lordship poses the question.
With 550 feet extension.
Yes.
Which is a breach of the undertaking given before the court.
Yes.
Understood. What problem has occurred? Have trees been felled?
No.
Nothing. Now, therefore, what in your estimation could be the reason for extension? I mean, suppose this was a breach. We accept it. If it
is an issue of gradient, then there are enough space to, maintain the gradient and end the flyover at the Robindra Bhavan.
A softer landing.
No. Otherwise also, Milord, they have extended far beyond it. Milord, it's not a question of, Milord, what will happen, what will not happen. It's a question of an highest officer of the state.
I'm making a statement which has not been kept. The promise has not been kept.
Yes.
But so what you wish to initiate? Have a
Milord,
contempt
as
initiate.
far as we are concerned, Milord, it is our duty to bring it to your lordship's
all right.
notice.
We are asking
Whatever
you.
view lordship takes, we have got
You
nothing.
have-
I have got nothing further to
We
submit.
take a view which is in consonance with law.
Yes.
Now, the question is this. Now, last part of the order is,
Yes.
needless to say that if in future, if the petitioner or any other vigilant citizen feels the stand taken in the affidavit by the state is not adhered to, he may be free to approach this court by way of appropriate proceedings. Now, what is this appropriate proceeding?
Well, an appropriate proceeding could be a fresh petition, could be a contempt petition, could be an IA also.
IA,
In a public interest litigation, normally lordship is not that technical, Milord.
we are
I
not.
can appreciate in an adversarial
We
litigation.
are not technical so far as questioning the locus is concerned. Because locus is not important in PIA. Except for finding that you are not a busybody or an interloper. Except that, nothing. But then, what do we do with this? What have you prayed? Necessary directions to comply with the order.
In
So therefore,
substance, we have brought the matter to your lordship's notice.
for the
In whatever form, that's an issue, my lord. Lordship will deal with it.
There has not been any felling of trees.
No.
There is no problem to anybody whose house is situated either way.
No.
There has to be something.
If lordship feels so, we've got nothing to say.
I think
But we feel, my lord, it's a very serious matter.
that's right.
A statement is made on oath and they are not keeping up that.
We have understood that. You have made that point very clear, Mr. Chaudhary. But question is that we will take adverse view of it or a very serious view of it only if the breach has caused felling of trees. The purpose was what? if the breach has caused any inconvenience to the public, if it has been extended to a larger
Yes, it is
distance.
causing inconvenience. It is not doing any good to, this flyover has not
Why
served any
did-
public purpose.
Yes, Mr. AG, why was it?
Lordship, let me go through this undertaking once more. How they are trying to misleading this honorable court.
No, no.
We know the simple and plain language and the words, everything which is incorporated in this paragraph. Let us read it slowly because an imputation has been made against me. So I have the right to give a counter. So Lordship, may I read it very slowly? The deponent, but one thing that no trees has been felled and there is a deviation of 550. That with that background, I am giving my submission. The deponent states that matter was taken up at the highest level and accordingly on 5/11/2024, the Honorable Chief Minister Assam has announced about the realignment of the proposed flyover without affecting two sides of Dighali Pukhuri. Now let us wait here. Dighali Pukhuri has four sides. Two sides are, one is the Handik College side, other one is this Gauri Sadan Road. So these two roads, the Abulla Road, these two roads have the trees. So there is absolutely no touching of any of the tree and neither any changes or tinkering with both the sides. Without affecting two sides of Dighali Pukhuri out of four, one and the trees standing therein. So both sides, Handik College as well as the Abulla Road, not a single tree has been touched.
That we saw yesterday when we were.
Yes, the Lordship knows this the whole geography. It is very near to us. One side, we have the High Court here. As per the proposal, the design of the flyover has been modified and now one side of the bridge will start from Lamb Road Point at GNB Road. Very specific Lamb Road Point, that is precisely we have done. And the other side will start GNB near Robindra Bhavan. That near has a meaning. So 500 meters here, 500 meters there is covered by this word near. 500 feet. So if they are trying to protect some commercial establishment, I have no comments to offer. But if we go by this statement and the undertaking given by the Chief Secretary as well as by me, we are fully following. So near Robindra Bhavan. So they are not stretching near, I am stretching the word near. So we have stopped it near Robindra Bhavan. And their own statement is that we have not calculated. They have said that 550. How far is 550 feet?
The length of this room would be 550.
Absolutely. This is their word. I am saying it is more than 550 feet. So they are making a mistake in their calculation also. So near Robindra Bhavan Point, resulting both the banks of Dighali, that means Handik College and Fayabulla Road, and trees will not be affected. It has not been affected, their own statement. In any manner whatsoever, the realignment of the flyover has been decided and necessary survey and preparatory works are
Made open, thrown
it
open
is
to
open,
public.
and although they are saying not if people are not happy, people are extremely happy. All our advocates, Lordship, may verify. They are coming, crossing this bridge, which otherwise they had taken 40 minutes. Now they are doing it in 12 minutes or less than 12 minutes. The people who are traveling from Jew Road, who are traveling from Nunmati, they are assessing this point in 10 minutes time now. So I'm not on those statements, but they are saying that nobody is happy with that flyover. Maybe some commercial establishment, even they will be happy because a lot of parking space has been resulted because of this flyover. So this statement against me or to the state or legal officer is absolutely incorrect, perverse, and figment of imagination of their side.
Yes. My lord, I was referring to the deponent of the affidavit. I was not referring to anybody else.
Law officer is the word they have used. Deponent is not a law officer.
Page 15 below, it is deponent. No, my lord, the question is very simple.
All right,
No, let us come to the case, my lord. Now, when we say near the Robindra Bhavan, what was the idea that was sought to be conveyed?
the other extremity should be somewhere around Ravindra Bhavan.
Yes.
A normal understanding would be this.
Yes.
But with the dominant intent that no felling of trees would be required.
No, my lord.
It has to be somewhere
No,
near.
Milord.
Near means
No,
doesn't
no.
stop there.
No, my lord, translocation of tree has taken place.
That's right.
10 number of trees have been translocated.
No disputes. We have seen that.
My lord, that's why I said, my lord, here a very senior officer of the government of Assam, and the matter was pleaded by the law officer of the state. where they made the submission. That's why this matter was closed. We do not know, my lord, if this statement would not have been made, how the court would have viewed the matter. Whether court would have permitted to go ahead with the construction. Because a statement was made, that to on oath and conveyed by the law officer of the state, therefore this honorable court closed the matter.
But we read it, but it's not a question of not reading it the way you want us to read it, but this
Yes.
is a simple statement which says
Hmm.
that as per the proposal,
Hmm.
the design of the flyover has been modified and now one side of the bridge will start from Lamb Road, that's okay,
Hmm.
road point at GNB Road, and the other side will start at GNB Road near Ravindra Bhavan point.
So,
No,
my
no,
lord, near
this is-
Ravindra Bhavan, my lord,
near
that
Ravindra
word,
Bhavan is not exactly perpendicular to Ravindra Bhavan. Now, let us look at it
yes,
from this angle. Near Ravindra Bhavan point, resulting both the banks of Digal Pokri and trees will not be affected
Lord,
in any
Lord,
manner.
let me,
So therefore, the dominant purpose
let
is
me
not
respond, no, let me respond, my lord. After the Ravindra Bhavan, there is the museum is there, then it is followed by district library, then it is followed by India Club. If it would have been the intention of the authority to convey a message, what is meant by nearby, then they would have said near the museum, they could have said near district library. Why they said near Ravindra Bhavan? The idea was that it will end here. So therefore, there is no question of felling tree. Whatever trees you have fell, further trees will not fell. To obviate that they will not fell further trees, this stand was taken. And having regard to the stand taken, the same was accepted by this honorable court. Now, my lord, if this stand would not have been taken, we do not know what would have happened. So therefore, I'm relying on a judgment of the Supreme Court on this point, my lord. 2016 3 SCC, page 70. But how an statement made on oath given before the court is to be construed? Well, I'll rely upon paragraph 27 to 31. Paragraph 27 to 31. In the first instance, the work order was issued to the skewed on 25/7/2007,
You are reading paragraph 26.
27 at page number
Yes, page number we have got.
Yes.
Internal page would be somewhere around.
63, I think.
Paragraph now. Yes.
Yes. In the first instance, the work order was issued to schemed on 25/7/2007, but it was not disclosed to the High Court when it was disposed of on so and so. Had the factual position been disclosed to the High Court, perhaps the outcome of the writ petition filed by BOC would have been different, and the issue might not have been traveled up to this court. Furthermore, apparently to ensure that the work order goes through, a false or misleading statement was made before the court on affidavit when the matter was taken up on 14/3/2008 to the effect that the work was nearing completion. It is not possible to accept the view canvassed by the learned counsel that the false or misleading statement had no impact on the decision rendered by this court on 14/3/2008. We cannot hypothesize on what transpired in the proceeding before this court, nor can we imagine what could or could not have been weighed with this court when it rendered its decision on 14/3/2008. The fact of the matter is that a false or misleading statement was made before this court, and that by itself is enough to invite an adverse reaction. In so moto proceeding against so-and-so, in brief, this court had observed
You have seen
that sanctity of affidavits filed by parties has to be preserved and protected, and at the same time, the filing of irresponsible statement without any regard to the accuracy has to be discouraged. It was observed by this court as follows. Courts are entrusted with powers of dispensation and adjudication of justice of rival claims of the parties, besides determining the criminal liability of the offender for the offenses committed against society. The courts are further expected to do justice quickly and impartially, not being biased in by any extraneous consideration. Justice dispensation system would be wrecked if statutory restrictions are not imposed upon the litigants who attempt to mislead the court by filing and relying upon false evidence, particularly in cases the adjudication of which it is dependent upon the statement of fact. If the result of the proceedings are to be respected, these issues before the court must be resolved to the extent possible in accordance with the truth. The purity of the proceedings of the court cannot be permitted to be sullied by a party on frivolous, vexatious, or insufficient. So therefore, my humble submission is, my lord, the undertaking given by the state in this case did carry a definite, my lord, meaning. Near Rabindra Bhavan means it is near Rabindra Bhavan. Or else it could have been near museum, it could have been near district library, as is the case now, my lord, or near India Club. So, my lord, they having not, respected the, the statement which they made or not, my lord, they are guilty, my lord. Therefore, I'll pray, my lord, in this case, the High Court awarded cost for making this false statement, and against that, this proceeding was taken to Supreme Court, where Supreme Court upheld the order of the High Court, my lord. Now, here in this case, my lord, I leave it to your lordships to take an appropriate view in the matter, and my lord, to uphold the sanctity of the judicial proceedings, my lord, necessary orders may be passed by your lordships.
Mr. Chaudhary, we are not getting persuaded to even ask for a response for the reason that now the overbridge has been constructed. The affidavit, I understand what you are saying. Don't think that the drift of your argument has not been understood by it. The other extremity has extended. Now, there could be myriad reasons for it, but this is no breach of the undertaking. The promise was somewhere near. You're right. They could have said, they could have taken a larger, perspective and could have said that it will end somewhere between what is that called? Rabindra Bhavan Museum.
I have got no further submission, my lord. Whatever submission I have, I made it, my lord. There is no commercial interest involved, my lord.
No,
The commercial interest will be Gauhati Museum.
No, right. But what we are looking at is that the flyover might make the traffic, convenient for people, number one. Number two, extending it further only adds to the gradient so that there is a softer landing. And if it does not require any, it has not required filling of any.
My lord,
trees.
for maintaining the gradient, there is space from that TC school point till Rabindra Bhavan, it will be about half a kilometer. I don't think half a kilometer is required for maintaining the gradient, ensuring a soft landing.
But see, this
Lord, then why such irresponsible statement was made on oath? Then it was an irresponsible statement made on oath.
I'm just giving one example.
No,
The common wall is
let him first exhaust.
I have got no further submission.
Question is that this I'm not seeing. I'm not seeing.
End of the day, it is your lordship's satisfaction which matters.
No.
According to us, it was a very serious matter.
Our view is.
And according to your lordship, this is a matter which can be
Our view is.
should be given a quietus.
This cannot be termed as an irresponsible statement because it was a ballpark kind of a assessment that it shall end there. Now, if it has not crossed, say, 1 kilometer, 2 kilometers, or the alignment has not been changed, that would have been a breach. Now, what do we do with this? When the flyover has been made open to public, why do we enter it? Then
No,
this
Lord,
becomes
I'm
a
not
litigation.
saying that flyover should be undone or it should now end at Rabindra Bhavan. But if this is how the Lord state, takes the Honorable High Court, then it's okay. If the Lordship feels it's okay, we have got nothing to say, my Lord.
That is a comment which
No, my Lord. And that statement also I'm making with all sense of sincere responsibility.
unless we find that there is a definite breach of the statement or a statement made so irresponsibly that perhaps if not considered in that perspective, the order would have changed. I don't think it's of that kind. Take it up.
only one thing, Lordship. Boundary wall of museum and Rabindra Bhavan is common. Once the Rabindra Bhavan ends, the boundary wall,
This
next building is
a minute.
museum.
This extension, the last extremity.
This is not extension, Lordship.
No. This last, where has it landed?
It has landed.
It is just,
End of my Lord, museum.
no, it is again an incorrect statement.
Huh?
Again
Yes,
a false.
end of
I'm
museum,
using the
no?
word false now.
before Ravindra, and in front of Ravindra. We are Ravindra.
Just 20-25% in front of museum after crossing the Rabindra Bhavan. This is
No, no, first is district, Ravindra.
I think it starts at district library. now.
District library.
Yes.
It ends at district library. If you
Yes.
Take it from somewhere.
And my lord, what we are saying was, in
no,
between
not district library. It is in front of the museum.
Just crossing the.
district
main
library.
gate. See,
The next building,
Ah.
these are three one after another. First building is Rabindra Bhavan. Second is museum.
Oh, in between, there is that office of the Nationalist Communist Party also, even beyond that, my lord. My lord, first there is Rabindra Bhavan, then it is the museum, then the NCP office, then my lord district library, and now I think it ends just before the district library.
just before the district.
Yes.
After the.
After the
almost in
NCP
front
office.
of The, yeah.
NCP office.
Otherwise, Mr. Sudhiri, one thing is striking my mind, the whole, this change of the flyover design was to avoid the wings to the developer. That was the prime
Yes.
issue. That was the prime issue, because if that would have happened, then all these trees would have gone. So therefore, the context was that remodulation of this bridge to avoid these wings.
All that we are saying is
Yeah.
that the alignment was changed and it was supposed to end at Rabindra Bhavan.
That's correct.
that is
but-
our
but
perspective.
The context was something different. Why this PIL and why
Yes.
they have changed their
We
designation?
are not asking you not to press this petition, definitely not. You have demonstrated that the promise was not kept to the words used in the affidavit. We feel that if this is something near can be explained as near. Near does not specify that it has to be 100 feet or 200 feet at that place. I mean, we have to take a practical view of the matter. This is not a breach. If you ask for this, then any statement by a lawyer or from either side would be difficult. I mean, if everybody would shy away from making a statement. This was at the early stages when the entire alignment had not taken place. So there was an object in mind. It appears to be so. I was not there. We did not pass the order. The bench in different composition had passed the order. So it must have been at that point of time that it will be somewhere near. See, somewhere near when I say that somewhere near airport there is a hotel. Does it mean that it has to be within the vision distance of airport? I mean, this is a ballpark figure which is made that is before the alignment. But we can't take it so seriously. It's not a breach to our understanding. Take note. The aforementioned IA has been filed, bringing to the notice of this court that the affidavit filed in the PIL number 64 of 2024 has not been. The promise made in the affidavit filed in the PIL has not been kept. It would be relevant here to state that while an elevated corridor / flyover road or / a flyover on GNB road from RBI office in Ambari to FCI Godown in Gauhati was under construction. Therefore, noted PIL was lost, bringing to the notice of the court that with the alignments proposed, many of the aged trees would be required to be felled. Which would cause damage to the already fragile ecosystem of the area. It appears that the court took up the matter in right earnest. But on an affidavit filed on behalf of the state, which we will be reproducing herein for the sake of clarity, the matter was rested, giving liberty to the writ petitioner or any other vigilant citizen to point out any anomaly, to point out any breach of such promise or any attempt of the state in not adhering to the promise made to the court. Promise made to the court. To Kalika, what did I say? In any, by way of any appropriate proceedings. The relevant portion of the affidavit filed on behalf of state in PIL number so and so, PIL number 64 2024 is extracted here in below. There is no dispute about the fact that the overbridge has been constructed and has been thrown open to public. The allegation of the applicant here is that the promise of keeping the flyover from Lamb Point to Ravindra Bhavan has not been followed. Stop. One extremity of the flyover, though starts at Lamb Road, but the other extremity goes 550 feet beyond Ravindra. Mr. Ken Chaudhary, learned senior advocate for the applicant, submits that at the moment there is no prayer for making any alteration in the already constructed flyover, which is open to the public. But the present petition is only for highlighting that in no case can an affidavit be filed by any responsible agency, including the state, which will not be respected in future or which projects a different scenario. And based on such affidavit, if any order is passed, it must be complied with in its entirety and not only in its letter and spirits. The undisputed position today is that with the two extremities at Lamb Road and somewhere near District Museum, State Museum, respectively, no trees have been felled. And there is no obstruction to any private accommodation or commercial establishment, if at all. They exist at the other side, at either side of the roads. At either side of the roads. The learned Advocate General, while responding to this affidavit, submitted that it was at the time of proposed realignment of the two wings of the flyover that an assurance was made to the court. Assurance was given before the court that one end of the flyover would be at Lamb Road and the other would be near the Ravindra Bhavan. So he has further submitted that Ravindra Bhavan and State Museum have a common boundary.
No,
That is a submission.
no,
Have a
Lord,
com-
there's a separate boundary.
It's a common boundary, Lordship, which is adjacent building, both
have a common boundary, or at least
adjacent to
the
each other.
buildings are.
Adjacent is different, common boundary is different.
Okay, all right, all right. What did I say? He further submits. State museum are adjacently located. And even if the other extremity of the flyover extends a little beyond the state museum, comma, it would still fall within the category of some point which can be very clearly said to be near Ravindra Bhavan. Mr. Chaudhary, learned senior advocate, however, submits that the purpose of filing the affidavit is only to ensure that no loose statement is made in the affidavit, which would have the potency of deflecting the course of the order passed by a court of law. And if at all the expression near was to be understood in this form, then perhaps the correct expression would have been somewhere around the state museum. We find that such criticism about the correctness of the promise made by way of an affidavit on behalf of the state is unfounded and ought not to merit any consideration, and it ought not to be considered seriously. We have taken notice of the fact that the other extremity of the flyover is about 550 feet away from Ravindra Bhavan, which would still be near, which could still be called near Ravindra Bhavan. What makes us not look at the breach of any promise, if at all it has been made, is also the fact that no trees have been felled in the process, and there could be some technical reasons for extension of the other extremity, like providing a softer gradient or a landing point. While commenting on the affidavit, where a ballpark figure, where a ballpark assessment was given, which either should have been more specific, or if at all, a benchmark was suggested, comma, that should have been respected, comma, Mr. Chaudhary has pointed out the observations of the Supreme Court in suo motu proceedings against R. Karuppan, comma, advocate, wherein it was observed that sanctity of affidavits required to be preserved and protected, comma, discouraging the filing of irresponsible statements without any regard to accuracy. He has also referred to the judgments of the Supreme Court in, I don't know how to pronounce it, SCIEMED, CIMED Overseas Incorporated versus BOC India Limited and others, 2016, 3 SCC 17. And Muthu Karuppan versus Parithi Ilam Vazuthi. This is 2011, 5 SCC 496, wherein a view was expressed that the filing of a false affidavit should be curbed with a strong hand to ensure and preserve the purity of judicial proceedings. And that giving false affidavit by filing filing a false affidavit is an evil which must be. Leave it. However, after having said that, the Supreme Court also cautioned that for an affidavit to be treated as false, there must be a prima facie case of deliberate falsehood. It cannot be lost sight of that before the alignments were revisited, a statement was made on behalf of the state that to avoid felling of trees or for damage, avoid felling of trees, the alignment shall be changed. And with the new proposed alignment, the two extremities would be at Ravindra Bhavan and Lamb Road. Stop. It was at the time when the real alignment had not been worked out by the engineers carrying out the project. Stop. If this extension, if this extended extremity is understood in the aforementioned fact scenario, this court fails to understand as to how the affidavit filed in PIL number 64 of 2024 was false, misleading, or had the potency of the court, had the potency of misleading the court into resting the petition with no further action. After having said that, taking into account that the flyover has already been made, has already been constructed and thrown to the public for its use, thrown to the public, thrown open to the public, and no trees having been felled in the process. What did I say? Close this application with
Lord, Honorable Justice Chaudhary has said one thing, my Lord. In another matter is closed, my Lord, that is off the record. Originally, my Lord, one end of the flyover was to take a right turn from the Divali side, and the other end was to go by Taibullah Road. Now, this would have resulted in felling of a lot of trees. Therefore, this PL was filed. Having regard to the public outrage, my Lord, state filed the affidavit. What the state said, to obviate the felling of trees, my Lord, we are ending at Ravindra Bhavan and we are ending at Lamb Road. It is in that perspective, my lord, we are before a lordship.
Before the PL notice was issued also, we made a statement that we are changing it.
Now,
It is not because of the PL we have changed it.
we have looked at it from a different angle. That was a time when realignment was being recalibrated. It was before
No,
that.
no, no, my lord.
Therefore,
No, this undertaking was given following the decision taken.
anyway,
Anyway, my lord,
somewhere near means, I mean, I was
with all respect, my lord,
going to medical college.
then why not railway station, my lord? That near.
Just a minute, I'm telling you something else. Yesterday, what's the
Medical college,
Hunger.
Hunger.
I was going to a function organized by the governor, Bihar Divas. So somewhere near Bhangagar, my brother informed me that this is the place where the Advocate General's house is located and Mr. Chaudhary's house is located. So I can say that it is somewhere near Medical College Auditorium. 5 kilometers this way or that way. Does it make a difference? I don't know.
Deeply.
Deeply.
Item number 6.
Service report is evident.
Six.
Services awaiting the report regarding service of notice on the sole respondent. The case is again at jointly.
8 May. Item 7.
Terms of the office note dated 23/3/2026, they were supposed to take steps. That has not been done on respondent number 4.
But the return party is left.
Let fresh notice be issued to respond number 4 with his correct and present address on steps being taken by the petitioner within period of 2 weeks from today. I mean, I think you have taken this, yes, you have filed the requisites for notice, but then again, you're not providing the correct address.
No, Your Lordship, the problem is that whatever the address we have already.
No, you find out unless we don't pass an order then.
Yeah, no, Your Lordship, just a minute, Your Lordship, only one submission. That on 1/12/2025, that it has been informed by the state council that the property has been sold to other person.
Then you find out the person who has to be noticed, plead him a party. We will issue notice to him. Do something. We can't give you anything without your PD.
No, the documents is directed to place before Your Lordship on that day. On 1/12/2020.
Mr.
I'm sorry.
Mr. Sharma, you appear to be passionately interested in this case. Otherwise, you would not have come up with this kind of appeal. One, you must provide the correct address.
Yes, Your Lord.
If the address which you have is not the place where the person resides, then you have to find out.
Yeah.
If you can't find out, you can't even ask for a substituted service of notice. You don't know.
Yes, Your Lordship, I am coming to that. Yes, I am.
You are not, you cannot possibly if you don't know the address. Which
That is.
newspaper would be circulated in which area? Suppose he has left the place, shifted to Delhi, then any Assam local newspaper would not reach him, no?
We will.
Find out
We
and
will.
tell
Set
us.
up.
If you want this case to be argued, otherwise we dismiss it on petition
No,
for the merits of the case.
No, Your Lordship, but the other person, sorry, Your Lordship, we'll take the side.
You just can't come and tell the court that he is not to be found wrong address, so do whatever you want.
No.
We will not entertain the petition. We'll close the petition.
No, we'll.
You're not able to provide us the address you want, all reliefs to you. 2 weeks time?
Yes, 2 weeks time.
Okay, as prayed for on behalf of the petitioner, let this matter come up under the same heading on so and so day. Find out the correct address, make a prayer. We are ready to allow that prayer of substituted service of notice of permitting you to implead the other person who has been sold the property, the buyer.
Yes. I'll do that.
We can't do it of our own, no?
Yes.
Chalo.
29 April.
I always react this way when somebody says that the address is wrong. This is the address I have. So what do we do? If this is the address and he is not to be noticed, will not pass.
Right.
And 50% of the times that a matter is adjourned in the orders is because of this.
It's because of.
No, it's not because of a report that the wrong address.
We are unable.
But you're expressing helplessness that it's the wrong address. What do I do? In the complaint, this is the address. So what would the court do?
We have to take care.
Yes.
Item number 8.
Isn't all?
All this.
So 33 days delay.
I paper short.
Why?
Filing.
33 days, even if you oppose it tooth and nail, I'm going to do well. क्यों मेहनत करना है? Don't waste your paper. Heard so and so. Appeal, renewal unknown, appeal to be processed. Briefly.
18th May. Item 9.
May please your receipt. In this matter, my lord, service is awaited as per the order.
Regarding service of notice on service of response. That's it. Adjourned this much.
That's a man, submit lordship. Learned additional AG, my lord, Mizoram informed me that the respondent number 6 had received notice, my lord. She had instruction to appear, my lord, but today she could not appear due to some ill health and now in Delhi solely.
So what are we saying? Awaiting the service of notice. So service of notice or appearance. Does it make a difference?
No.
4th May. Both 9 and 10.
See responsibility. You should not make such a statements in court for the reason that the additional advocate general informed you. Additional advocate general is not supposed to inform you. He's not here. And then he is talking about some other advocate. I mean, why should you say all this?
Sorry, my lord.
Wait for the time. Otherwise, also you needed an adjournment. We have given you an adjournment.
Oh, like that.
Item 11.
May please your lordship. I have to receive the notice, my lord, I have filed my government today, I want to file the application.
Mr. Patwari, you want to contest?
Yes, madam.
Mr. Patwari, learned advocate, has appeared on notice and submits that he shall be filing his affidavit in opposition by the next day. Let that be done on or before the next day. Re-notifies him. This is an application seeking condemnation of delay. I'm not going to repeat it.
6 May.
Development.
Item 12.
Notice, both modes, 2 weeks returnable, give a date.
May. Item 13.
May please.
Who appears for the state? All state respondents. Ms. Sharma, accept notice? Just concede. 45 days delay. We have heard so and so. With an application seeking delay. Of the reasons stated in the application. The rules can be known.
55. Item 14.
8 days delay already. 8 days delay.
All state respondents.
My five. All of the.
1 to 5 pending council education and 2 and 4 pending council finance.
Anybody here? MS Sharma informed the respective state council. 8 days delay, we are condoning it. Only state respondents, look at the name of the standing councils of the department, inform them that we have taken their consent.
13 May.
My lord, similar reticular fix on my lord 12 of May yesterday.
12 of May.
Okay, 12 May.
March.
Item 15.
Private respondents. Notice. Take the date, take the specifics, Mr. Gogoi, later.
4th May.
2 weeks or whatever. date.
By admission, item 16.
This has become infructuous.
Well, it is so, but
We are not going to say anything.
no, my lord, there is something, my lord, which I would urge that your lordship will kindly consider. They are trying to weave into certain facts, my lord, which were not there in the proceedings.
No, this was
And
because,
on the-
this
on
was
the-
because the state, ushered them in.
No, my lord, on the basis of those very facts, my lord, they are now approaching this honorable single judge. Now, unless and until your lordships could clarify.
Can you stop that?
No, I'm not on whether.
Stop that.
No, but at least your lordship can clarify that they are trying to put words into the judgment.
You are there. No order will be passed without noticing you. You say that Mr. M.K. Chaudhary is putting words in the mouth of the court.
No, I'm not saying about any counsel, my lord. Your lordship will kindly see the.
We are telling you, you have not uttered his name. We
Well,
saw him stepping in, therefore we have said his name.
No, my lord, your lordship will kindly see the paragraphs that I would like to place before your lordship in the IA.
We otherwise would not have interfered with this. You know, we were absolutely unhappy with we were not unhappy. We are not on the same page with the single judge. That order of transfer, for whatever reason, whether it was in public interest or on the asking of the appellant or respondent, if it was made, it could not have been undone so lightly. That is also in public interest for the state to maintain the personnel. Now, we would not have interfered because there was no malice there. It was only fortuitous that the lady was shifted. So therefore, instead of passing an order, setting aside the judgment of the single judge, we explored whether both of you could have been accommodated.
Now, there, my lord, they are trying to understand it in the manner
But the fact is
that your lordship's intended.
one person, Mr. Who is for the appellant?
No, I am for the appellant.
The appellant has remained at that place for 8 years. The other has remained at that place for 30 years. Now, in that case, can we preclude the state from passing an order?
No, my lord, I am not on that, my lord. Your lordship will kindly consider, my lord.
Yeah, no, they have again passed an order, no?
Yes.
No challenge it.
No, that they have challenged before the single judge. Now, in the proceeding, my lord, what they try to do, they try to say that as if your lordship passed an order and the state has also given concession that both of us will be accommodated at Gauhati. Whereas it is not there. Like, my lord, I'll only.
You can always object to his statement, saying that such observations of the court, even if it is not in black and white, please don't take notice.
My lord, that your lordship can.
Why should we?
My lord, because
we don't remember. Not at all.
My lord, it is your lordship's order which are being. My lord, which are
You
being.
defend it, what you are saying before us.
My lord, it is your lordship's order which they want to interpret in that manner.
Who will interpret? The salaried civil judge will interpret. They cannot interpret.
And if that is the basis of the order, come back to us in appeal, we'll set it at naught. Can we pass an order on this? That somebody is trying to misread your order?
No, my lord.
Mr. Datta, please.
My lord, kindly see the statement, my lord, that has been made. If your lordship will kindly.
No, we are not looking. I mean, not because we don't want to hear Mr. Datta, but because we don't find it to be so pressing that division bench should focus its attention on it.
Well, your lordship said that both, the respondents.
We did not say these oral observations. If somebody quotes it, it is for the wisdom. I leave it to the wisdom of the single judge whether to accept it or not to accept it. Suppose you come and say that this was what was observed in Supreme Court, but I take it as true unless I see the order. I mean, I leave it to the wisdom of the single judge. Can we train them? Can we ask them to think in a particular way? Would that not invite another flag by the single judge saying that what do you think of my intellect? I would not go by anything which is.
No, I am not on that, my lord.
Anyway, let us put an end to it.
My lord, I am just saying that on the basis of these very statements, they wanted an order from your lordship in the IA. That is why I am feeling concerned.
Did we pass an order?
No, they have not withdrawn the IA. They initially said that they
have filed a petition. Without that, it shall not be heard. So that means that the petition, everything is withdrawn. Don't worry. I don't know. There is some unfounded fear. You are some kind of an apparition which is haunting you. You are trying to see a ghost which exists, which
no, I am not meaning anything in the proceedings that is pending before the honorable single judge. I am only saying that in the IA that they have filed before your lordship, in the IA they are saying this, and they are seeking an order from your lordship. That is why I am pointing it out.
Mr. Chaudhary has not uttered a word. He wants it to be dismissed as infractuous.
Both the appeal and the, my lord, DI.
Everything, all proceedings. Again, initially, this appeal was filed against the judgment dated 2/11/2025, passed by a London single judge of this court in WPC number 3585 of 2025, whereby the transfer of the respondent number one herein from the post of Registrar Labour Court Gauhati to the post of Registrar Industrial Tribunal Dibrugarh has been set aside, and a fresh order of transfer has been directed to be passed by the competent authority. This court expressed in the beginning that it would be appropriate if both the appellant and the respondent are accommodated at a place which is near their suggested choice, for the reason of the difficulties faced by them, and they having remained at their respective places before transfer for 8 years and 13 years respectively. A fresh decision appears to have been taken by the state, by the government, by the government, transferring both the appellant and the respondent to different places. Mr. M.K. Chaudhary, Learned Counsel, Mr. M.K. Chaudhary, Learned Senior Advocate for the respondent, number one, has challenged the fresh order of transfer of respondent number one in a new by way of a writ petition. Stop. Hence, the present appeal has become untouched. Stop. All interlocutory applications pending with this appeal also stand dismissed as having become untouched. Where is the difficulty? We have also stated what we had said.
I'm obliged.
Your fears also appear to be allayed. We have said so.
Yes, yes.
And without breaching the law of transfer. Because both of you were at the respective place for over 10 and 13 years, 8 or 13 years. So otherwise also the state directive of transfer is in breach. 3 years normally you should be transferred. But otherwise, fresh order of transfer. So you challenge it.
Obliged.
Item 70.
Yes.
Lordship, in this case, I'm not pressing regularization part. Simply, Lordship, pension part, Lordship, kindly have a look at. In the light of this program.
This is 142 order. This is 142 order, sir. We can't allow this. Would you need it?
No.
Mr. Mazumdar, you're Mr. Mazumdar.
Lordship.
I'm sorry, this order comes to no help so far as you are concerned. So far as this court is concerned, we can't pass. We give. We have heard Mr. RB, Mr.
L.R. Mazumdar.
L.R. Mazumdar.
L.R.
Mr. L.R. Mazumdar. Learned advocate for the appellant. Learned advocate for the appellant. And Mr. Nayak, learned additional advocate general of the state. The appellant was hired on a daily use / muster roll basis on 1st of August 1993 and retired on 31st of December 2024 without his service ever having been regular. He claims to have performed the same duties as the regular employee for decades, but received only the minimum pay scale after a 2017 High Court judgment of he being paid the minimum of the regular scale. Next, after his retirement, he had applied for gratuity, which was not paid. He approached this court. He approached the court with twin reliefs, namely regularization of service with effect from regularization of the service and payment of all pensionary benefits, gratuity and arrears. However, the writ petition was dismissed. However, the writ petition preferred by the appellant was dismissed. A perusal of the order, a perusal of the judgment impugned reflects that the prayer of the prayer of regularizing the services of the appellant could not have been allowed, for it would have been in direct violation of the earlier division bench judgment of this court in Upen Das, which had followed the judgment of the Supreme Court in Umadev. A court cannot direct for regularization of a muster roll employee who was not appointed through a proper process. It was further held by the learned single judge that the reliance on the verdict of the Supreme Court in the case of Dharam Singh citation was unfounded. In the case of Dharam Singh, the employees were selected by the UP Higher Education Service Commission between 1989 and 1992, whereas the appellant herein was simply engaged locally as a daily wage worker. Thus, the view of taking a liberal, thus the liberal view taken in that case with respect to pension and gratuity would not be applicable in the case of the appellant. Mr. Mazumdar, however, submitted that the learned single judge ought not to have allowed the state to hide behind the shield of Uma Devi within for justifying exploitation, especially when he had served for decades with identical permanent duties. Even today, learned single judge, according to Mr. Mazumdar, did not take into account the spirit of the Supreme Court judgment in Sripal the case. Sripal. And again, in Sripal wala declama. Do you know, Mr. Naik, the citation of Sripal?
Citation, I will give it.
Sripal. 2025. What did I say?
Lordship, it is there in my appeal memo, page 91 onward.
Sripal and another versus Nagar Nigam Ghaziabad, 2025 SCC online SC 221. The core submission of Mr. Mazumdar therefore is that the learned single judge did not appreciate that long-term denial of pension and gratuity to employees who have served for 30+ years would violate the basic principles of fairness. After having heard the learned counsel for the parties, they are of view that no other order could have been passed by the learned single judge, especially in view of the fact that there was no regular, the appointment of the appellant on the muster roll was not a proper process. So that apart, after his engagement on purely temporary basis in the year 1993, he started getting the basic minimum scale of equally placed regular employees from 2005. This was never questioned by the appellant ever in his service tenure. Under such circumstances, the prayer made on behalf of the appellant was not backed by any reasonable argument for the same, for his prayers to be allowed, for it to be allowed, finding no merit in this appeal to business.
All right.
I will go now. The next honor for ready benefit. Follow the next. Yeah, hey, do we have any, Mr. Nath? Do we have any open jail here?
Open jail, one open jail is there.
Where is that?
That is Jorhat.
How do you respond to this?
This copy, I'll take, I have to take this.
Mr.
My lord, probably they have not have with the copy, my lord.
Give him a copy.
My lord.
Give him a copy, like Mr. Nath. Learned government, senior government.
No, my lord, all other states are also party.
Oh, yeah, Mr. Nath responds. Has the monitoring committee been constituted?
No, right, for the first time, my lord, it is no notice.
First time.
First time, my lord. The notice be issued, my lord.
Well, I'll take notice on behalf of respondent number 1, 5, and 9.
Open correctional institutions,
OCI.
which are commonly called open jail, open prisons, are not functioning in reality. Next, this fact was taken note of by the Supreme Court in a PIL laws by an activist called Suhas Chakma, bracket WPC number 1082 of 2000. the Supreme Court was of the view that the institutions have a constitutional duty to protect the dignity of prisoners, give them equality of opportunity, and help them reintegrate into society. Open correctional institutes or institutions are such places where there could be a transformation of the prisoners. Next, open prisons are special places where selected prisoners live in a more open and normal environment. They can go out during the day to work, learn skills, stay with the families in some cases, and slowly get ready to return to the normal life after their sentence. The idea is to reform and rehabilitate. It was found by the Supreme Court in the aforementioned PIA that the orders passed within courts in human conditions in 1382 prisons case had not resulted in any significant improvement in the situation. It was therefore thought that a clear and practical direction be issued addressing the problem in a targeted way. One of the most important directions of the Supreme Court in this regard was creation of a strong monitoring system so that orders towards such target are not ignored. A direction was given to every High Court in India to immediately register a suo motu case, suo motu writ petition, in order to keep a continuous watch on whether the state is following these directions of the Supreme Court. At the same time, every state and union territory must set up a special monitoring committee for the management of open correctional institutions, which committee is to be headed by the executive chairman of the State Legal Services Authority or a former High Court judge, and would include senior officials from the Home Department and the Prisons Department. The mandate of the committee would be to make sure that open prisons are built where needed, that eligible prisoners are identified and transferred quickly, and that the institutions function properly. Stop. In case of any problem, there should be an immediate resolution. The Supreme Court has also fixed a strict timeline for the states to form these committees within 4 weeks, submit their first progress report to the High Court by 21st of August 2026, and for the High Courts to send a yearly summary report to the Supreme Court starting from 31st of March 2027. The entire purpose is to turn open prisons into real tools of dignity, equality, rehabilitation, and social integration, instead of letting them remain unused or ineffective. Mr. Nath. आप सब नाम बताइए, all stakeholders,
Probably Mr. Nath representing 1, 5 and 9.
so and so.
I'm for response number 1, 5 and 9.
Mr. Nath, आप लोग दे दीजिए अपने स्टेप।
Gotcha.
Then so and so accept notice on behalf of. They shall respond immediately after complying with the directions of the. Let separate copies of the petition. Let separate copies of the brief be furnished by the High Court to the respective advocates who have accepted notice on behalf of the respondent. Stop. Detailed affidavit must be filed within a period of 2 weeks. That is all. कब तक last date बताया?
21st of August.
टाइमलाइन में आपको कब बताया?
ये मतलब 21st of August.
21st of August. अगर 2 सप्ताह में सब करके बताइए.
Gotcha.
3 weeks कर देते हैं.
Gotcha.
We are only in April, only in March, so 3 weeks. April के 3rd week तक तो
Gotcha. After 9th is better. मतलब.
You understand, we understand, this is specific timeline given.
True.
Respond.
Gotcha.
That would not fall within the domain of election. What is that called? The model code of conduct.
Gotcha.
It's in compliance with the Supreme Court's
Yes, yes,
order.
absolutely,
You
absolutely.
just have to work on paper, you have to constitute a committee, you have
Yes.
to make the members, and you have to
Yes, yes.
just
Don't
follow. And we will be vetting those reports.
Mala.
Let counter affidavit in the meanwhile be filed positively. Only after, but only after constituting the monitoring committee, but only after. It is expected that by that time, the monitoring committee, so directed by the Supreme Court, shall be constituted. And shall be constituted. Re-notify on. After 3 weeks.
Okay.
And after 3 weeks, then you will.
Date, 20th April 2000.
Take it back to 21st.
Let it be on 22nd.
22nd.
26.
But do everything and then come get back to us.
Yes, sir. All right.
Here they come. Thing a bit. Next point.
Item 21.
Gotcha.
Wait, please, Alon.
Just come back after 10.
Yes, sir.
Get ready.
Item 21.
Next, please, Alon.
Yes.
The petitioner herein was terminated from service, and was no disciplinary proceeding was initiated. But relying upon Article 311 provision.
11(2)(b).
Yes, madam. And challenging that, we approached under single judge. But our petition was dismissed and being agreed, we are before the lordship.
What?
Yes. Lord,
It was an extended period of probation, no?
no, Lord. No, he is on the verge of retirement, Lord.
Oh, it's on the verge of retirement.
Yes, sir. Lord, he was a inspector of police, Lord, and was working as OC. Lord, an FIR was registered, though he was not
Oh,
named.
there's a police officer.
Yes, yes.
The police officer who could not save this woman from being ravished in jail.
My Lord, we'll see on 29th, Lord.
And where did you run away?
Lord, we had not run away, Lord. The appellant
You
had
are
not run.
accounted, no?
Lord, I am not being, Lord, they could not find me, Lord, I'll be termed as a.
If you are a police officer, they couldn't find you. Unless you hide yourself. And what was the occasion? Why did you hide? I mean, that's on merits. We understand. You don't.
No, I am not on that.
Question to us.
But-
No, but these facts weigh with us.
The law is with me.
You
Lord.
can't. Law is against you.
Law is with me, but you
The
respect
facts are
your
against
lordship.
you. Law is against you.
Lord, just recent judgment of the apex court I rely upon, Lord.
Policy.
In the case of
I
Manohar,
remember only Tulsi Ram Patel.
yes, yes, no, that has been relied upon. That is the benchmark, not.
Where is the dismissal order?
My lord, page finds at page 58. That is the type copy. And one day, my lord, I have been dismissed. 29th, I am suspended. Based on same facts, they say that a department proceeding should be initiated.
That will take us to the relevant portion of the single judge's order.
My lord. Okay. I would come to page 93. But
Let us see the order of dismissal first.
yes, yes, lord. Please. And before that, if your lordship permit, not, I'll just show one page, page 56. This is order of lord suspension.
Suspension.
No, they are the authorities of the
What
opinion.
was the charge against you that committed?
No charge, charge, not. No, I have. FIR has been annexed, lord. Under section 12 and 14 of POSCO Act, lord.
No, where is the FIR?
My lord will kindly find at page 49. Lord, I'm facing trial in that case, lord.
And what happened? The investigation ended in,
Lord, charge sheet has been filed against
have you
me.
been charge sheeted or?
Yes, yes, I am facing trial, lord.
You're facing trial.
Yes.
What is the stage of trial?
Evidence plus 21 witnesses have been examined, lord.
21 witnesses have already been examined.
Yes, yes.
Yes. There's no infirmity with the judgment impugned in my humble submission. If I may most humbly draw your lordship's attention to page 97 of your lordship's brief. Line number 5 from top. While such a possibility may be available, however, in the present proceedings, the only question urged before this court is whether in the impugned order, reasons were recorded in the writing expressing the satisfaction that it is not practicable to hold the inquiry. Upon due consideration of the facts urged. Where are you reading? Page 97, line number 5 from top.
Page 58.
Let us see page 59.
My lord, may start with 58, my lord. Your lordship would see there is an inquiry report has been referred, my lord. That is dated 29/6. Peruse the inquiry report dated submitted by so and so in connection with the above case. The said inquiry had to be ordered as allegations were received against so and so, who was the OC so and so, so and so. Therefore, whereas from the inquiry so conducted and after going through the inquiry report supported by the statement of the victim were recorded under so and so, prima facie it appears that the allegations against the person which are serious in nature are substantiated. And whereas Honorable High Court so and so, but relying upon that judgment block, any order it deems to whether this is recorded in writing, that is not the law that has been stated. Now, whereas in the present case, I am satisfied that it is not reasonably practical.
Because you absconded.
But in one day I cannot. Lord, there is a legal connotation so far as absconding is concerned, Lord. Lord, in one day this inquiry has been done. I've been suspended pending departmental inquiry, and the next day, Lord, I've been terminated. And Lord, there is no satisfaction as such.
My lord, similar facts, my lord. Just I'll,
We are not getting persuaded because of the extreme case of moral turpitude.
my lord, only statement of
What
the,
what could be a more heinous crime?
my lord, allegations are very serious,
Allegations are serious.
very, very serious, my lord.
So we are not doing anything. Of course, it is weighing heavily on our minds. The impracticability does not mean complete impracticability. It means the usage of the words are not, what is the use of the word?
It is not reasonably practicable.
Reasonably practicable.
Yes.
It is not impracticable in its, I mean, absolutely impracticable. And that is, on this wording, judgments have been delivered.
But in fact, the judgment I am relying upon, my lord, on similar facts, my lord, I'll submit, my lord. The apex court has held, my lord. Even there was a finding against the delinquent officer in that. My lord, here only the statement of the victim girl has been,
We are referring to Ved Mitar Gill versus UT Chandigarh,
my lord.
2015 Supreme Court. This distinction has been, very specifically expressed. The words used are not practicable, but not reasonably practicable. And the Webster's dictionary would define the word reasonably as in a reasonable manner to a fairly sufficient extent. Thus, whether it was practicable to hold the inquiry or not must be judged in the context of whether it was reasonably practicable to do so. It is not a total or absolute impracticability which is required by clause B. What is requisite is that the holding of the inquiry is not practicable in the opinion of a reasonable man, taking a reasonable view of the prevailing situation. When did you absconded and you were taken into custody immediately?
Yes, after a few days,
After a few days.
my lord.
So where were you during those days? When was that decision taken? After you came out from,
No, my lord. Lord, once I was informed about my suspension, my lord, I could not join my duty because that wasn't.
Suspension means you sit at home.
So,
They'll fix a responsibility on you, no?
my lord, after suspending me, my lord, they did not allow me to join. And on 29/6 it was done, my lord. On 9/7 I was arrested. And when I was,
Suspended, they will fix a place for you.
no, I'm,
They'll say that.
yes, we cannot go out of station, lord.
You were not being found.
Lord, absconding, lord.
You were suspended on the next day when the FIR was lodged.
No, lord, an inquiry was conducted on 29/6. That very day, based on same inquiry, I was suspended. And that based on that suspension, lord, that order reflects that pending departmental inquiry, it was my suspension. And next day, my lord, I was terminated.
And you went to jail bed.
On 20, lord, next month, 9th of July. That suspension was on 29/6, termination 36. But that order copy was not communicated to me. When I was in custody, then only my relative was suspended. Lord, I'll try to persuade your lordship, lord.
You respond. See, there are dangers in accepting this proposition also, what this state has done. But because there's a very serious offense concerning a 17-year-old girl, and he is in a special relationship. I mean, he is in a special protected position. He was the officer in charge, and she was in custody. She was in police thana. I mean, I'm not able to go beyond that. I'm so sorry to say. I'm not,
Very
the
unfortunate.
allegations could be false. We don't know. But where is the ground of reasonable impracticability? That you'll have to explain, no? Otherwise, we'll have to record all these findings, the background facts. We are not at all, we are only thinking against Mr. Dubey.
I understand.
So thinking against Mr. Dubey all the while, and the time that we are taking in passing an order should have been instant dismissal of the appeal, but we have to be conscious of the fact that law should not be tinkered, number one. The law should not be misinterpreted. Therefore,
Only thing that has fallen from this honorable court in the course of proceedings today. He is a police officer. he going absconding, he not being able to be found. Well, he has absconded, my lord. He has run away from the situation of what he has done, my lord.
My lord, for a moment, your lordship would see para 31 of the judgment, my lord, for my satisfaction.
Reasons were recorded, my lord. The only ground he was up before the honorable single judge was that reasons were not recorded in the order impugned. That is there, my lord.
Just a minute. Respond to this appeal.
I will.
But in fact, para 31 of this judgment, my lord.
So the way I only be arranging my prejudices, I must be very.
But I'll
Only
try to.
how to dismiss your petition straight away, but because I am not used to doing it, I must be satisfied on legal count as well.
Let the answer,
Otherwise, there is no reason why I should entertain.
my lord,
your argument
I'm
for
deeply
a
obliged to your lordship's, my lords. The answer to your lordship's query is para 31 of this judgment, my lord. In 41, para 31, this Manohar judgment, my lord.
second.
The same, my lord, inquiry was also conducted in similar fact.
Paragraph 31.
Yes, my lord, page 26, your lordship.
ये तो हमारा मुझे तो discount background at 311 2B. I mean, we are looking at something else. You're talking about the merits of the case.
Let,
We are talking.
there also an inquiry report was there. The
Inquiry reports a similarity. How you trace
the apex court has said that there should be a subjective satisfaction so far based on the materials.
subjective satisfaction to ही है, not based on objective standard.
That
That you can say.
yes, yes,
Subjective
that is my whole case, my lord. That is my whole case. Then para 41 also, my lord, is allowed to see. 40 and 41.
It was addition to Kiban. No. Yeah. 12th March. They're not even persuaded, Mr.
Malad will see in one day he forms an opinion that he is an absconder. And Lord, the reasoning is he's not cooperating with investigation.
Yes,
absconded.
saying something does not have a bearing in 311 months.
No.
After inquiry, you could be dismissed. communicate
Yes, yes,
with the
that's
punishment.
altogether a different chapter, my lord.
Everything is there. But interfering with this, and how have the witnesses deposed against you in the trial? It'll take a long time. These are impracticable because you're facing.
My lord, with due respect, my lord, that would be in the context of the trial, my lord, not with the context of the department proceedings, my lord.
That's what I was saying. that
My lord.
Otherwise, the busy facing trial, it's a day-to-day trial because it concerns a woman. We can supplement our
Yes.
reasons.
My lord.
We are not getting persuaded, notwithstanding the fact that the order is cryptic. Notwithstanding the fact that the single judge slightly misdirected himself in dealing with it.
In fact, I was put the burden of, my lord, making fair, my lord, candid disclosure.
No difficulty.
That is not perhaps required, my lord.
But we are not coming out of that problem.
My lord, will see in that judgment, my lord, there was an inquiry report. My lord, here also, my lord, no,
Can
nothing.
this be an impracticality or not, that you would not be released on bail, you would be dismissed from service, and then you might abscond. You are facing trial, so in fact, there should be complete availability of you and calling you to the police, to the place where inquiry is held. Then to same police officers. I mean, there are many things.
Yes, sir.
Impractical.
My lord, and see in this judgment, my lord, in fact, there was statement
The
by.
possibility of your being lynched, killed, also. You know what happened in Telangana?
Let my submission for your lordship's consideration is this. But they even not initiated to contemplate that. One authority says we will start. Next day you are absconded. We can't do it anything.
What is very with us is this. This girl did not know you.
My lord.
Not that she is falsely accusing you. She's not falsely accusing. She goes to the police station because public caught her. Caught a young girl moving around with a boy trying to elope. They caught. I mean, I don't appreciate such vigilance.
Well, that,
Because that was not the police station, but they had to be kept. One, it was improper. The SI should have taken
Yes, sir.
care not to keep her in custody. Not in custody, but in the premises of the police station. He kept and then disrobed her. Photograph that was there in the. I mean, this is beastly. This is beastly. Why should law come to the aid of such person? I mean, that's not strictly answering 311.
yes,
I
Lord,
understand.
I go down to your lordship, Lord, so far as view is concerned, Lord, but there is already a trial, Lord. Can I be condemned without, Lord, that?
No, this is no condemnation. You have just been thrown out of service.
Lord, that they could have proceeded, Lord, if I.
You have served. You're almost on the verge of retirement.
I have retired, Lord, in fact.
He has retired.
October.
So yeah, you don't require any salary. You have retired.
Yes.
Don't press it. No, you press it, but don't be so. I mean, maybe just yeah.
If I may be
My lord, may
permitted,
also peruse the report, my lord, that is not before your lordship.
We will start writing from Tulsiram Patel. That would be a
Yes.
and then we'll go to Vishal. Also, in these cases in between that shall be discussed. And we have to justify. Otherwise, what is the fun? We have been dismissed from service. You have been removed, dismissed.
Dismissed.
So you don't get pension.
And I would have my own fate in the criminal trial block.
And they are going to convict you for life.
yes.
Because it's an open and shut case. That's the statement of the victim, which was immediately reported. 164 statement recorded. She doesn't know you, but she made a statement. She identified. What other evidence is required? She was alone in the room, and not that she is. She does not understand the nature and quality, and it is not a fact that you arrested her or arrested her boyfriend, that they had any animus against you. Nothing. In fact, on the next day in the morning, she would have expected a bona fide police officer, a good police officer, or even, a citizen, not necessarily a Samaritan, he would have escorted her to the correct police station. So normally there was no reason for the woman to complain. You had provided her night stay. Now these things start working in your head, and then why law
I'd stay without her clothes on.
and why the law should come to your aid? This is what, but so far as practicability is concerned, the reasoning given does not appeal to us. That's a different aspect altogether.
Also, as has fallen from this honorable court, my lord, Vedmita Gill, paragraph 25, my lord, thereof.
What?
Vedmita Gill, my lord.
And what does it say, paragraph 25?
The determination by the competent authority, when viewed dispassionately with reference to the duties assigned to Vedmita Gill, leaves no room for any doubt that the competent authority was justified in concluding that the 4 prisoners referred to above would never have escaped if the appellant Vedmita Gill and the petitioners had diligently discharged the duties assigned.
No, so impracticability is where?
Well, that oh, my lord, in impracticability.
We are on there.
Right.
The ratio supports my case, my lord, in fact.
Show it to you.
Paragraph 26.
respond. Let us, no amount of these safeguards.
Lordship had asked a question.
We are
whether-
able to see through for the reason that we have to look at it from fresh perspective.
Yes,
On a different day today, nothing seeps in, nothing in his favor.
Lordship had asked a question. My lord. That aspect has been handled in paragraph 26 of that judgment, the weight meter bill judgment, reasonably practicable.
Now that's just reiteration of what Tulsiram Patel said. But then the satisfaction has not to be of the court. The satisfaction is of the disciplinary authority. And that can be deciphered only with the reasons given in the order. It doesn't say anything.
Other
If
than
you would have
him,
said,
other than him absconding.
if you would have said that this was a case of an inter-religion elopement and holding any inquiry would have, there
Yeah.
could be a risk of threatening of witnesses or some problem or social unrest or some indiscipline.
Look.
But I can't provide the reasons. No, the disciplinary authority, this is what comes to mind, and therefore immediately he was dismissed. 311. It was a case of that kind. And then they would have also thought that any delayed inquiry would have resulted in unrest in the area. It is because this moral thing and social compulsions are no grounds, but Tulsiram Patel takes note of it. Says that yes, this also makes the inquiry proceedings reasonably impractical. But these reasons have to come from the appropriate authority. We can't substitute our reason. We can only see that there was a possibility of impracticability. The police officer manning the police station where a 17-year-old girl has been vanquished. And it's an inter-religion kind of a thing. It could create chaos if he were not dismissed. And then his saving life is a bigger, responsibility of the sovereign. This could have been the reason. He's not asking for mercy or he's not asking for acquittal or for that matter reinstatement. He says that there is a departmental proceeding, criminal case is pending, proceed against me departmentally, bring witnesses. Therefore, the requirement. Now, which police station employee, which all members of the police force posted there, all of them could have been held guilty. That they supported. This was the impracticability of holding an inquiry. Ye kaun kahega? Ye hum kahenge. All of them were witness to it if they were present. If they were not present, they were also neglecting their duty.
That is also not to be.
Every time that I think against you, Mr. Dubey, we will hear you on some other day. This is the ground. But how do I justify that this ground has been supplied by the division bench and not by the disciplinary authority? How do we justify that? Normally, this kind of anomaly appears. There is an SOP of the police department also how to go about. This is for senior officers who are the disciplinary authority for, maintaining the police force. देखते हैं you respond. Take it. You have heard Mr. R. Dubey, learned counsel for the appellant, and Ms. Sumitra Sharma for the state of Assam. A minor girl of 17 years faced a harrowing experience in the night of 21st of June 2023 in Ghogra Park police station, where she had been brought by local vigilante group in order to prevent her from eloping with a friend. any case could have been lodged only within the police station under which jurisdiction the offense had taken place. Ghoghra Park police station was not the police station where the case was required to be registered. However, since the victim girl was brought to the police station, she was kept in the premises of the police station in the night. But the appellant, who was the officer in charge of that police station, appears to have gone berserk and forcibly took new photographs of the girl under the point of the girl. The victim girl immediately complained about it, made a statement under section 164. And a case was registered against the appellant under various provisions of the under sections of the IPC as well as the POCSO Act 2000. The appellant was suspended on 29th of June 2023, pending a departmental inquiry. The allegation against him is that after this incident, having been reported by the victim, the appellant had absconded. What is distressing to note is that on the next day, it would be relevant to note that on the next day of his suspension, that is on 30th of June 2023, he was dismissed by the disciplinary authority by invoking special emergency powers under Article 311(2)(b) of the Constitution, read with Rule 10, bracket 2 of the Assam Service, bracket Discipline and Appeal, bracket close, Rules 1964. The records further reveal that the appellant was arrested in the criminal case referred to above on 9th of July 2023. It was during his confinement in jail that he learned about his jail mein pata chala.
Yes, a relative was served and we came to know only as.
It was during the period of confinement in jail that he learned about his dismissal through a relative who had been served with the copy of the judgment. Consequently, a writ petition came to be filed by the appellant, challenging the dismissal as arbitrary, illegal, and violative of natural justice. Primarily on the ground that no appropriate / adequate reasons were given by the disciplinary authority for dispensing with the inquiry, and that he had never been supplied the inquiry report, preliminary inquiry report, on the basis of which he was suspended. And that the action taken of dismissing him at the fag end of his career was even soberly put, post haste, haste. The writ petition preferred by the appellant, however, was dismissed. justify the reasoning by the disciplinary authority. Justifying the adequacy of the reasoning provided by the disciplinary authority in skipping the inquiry. And also taking into account that the appellant had failed in his duty to protect a minor girl in the police station premises of which he was the officer in charge. Now, with this mindset, if I decide, then it becomes hence this appeal. MS Sumitra Sharma shall respond to the memo of appeal by the next date. Re-notify.
28 April.
Today, if I could have concluded, I would have also justified given
12 May.
Try and read something into it. Let's see.
Item 22 to 25.
I have received the paravise from him yesterday. So last order notice, I have to file the affidavit on or before my lord 6/4/2026. They have.
Somebody had mentioned.
I have mentioned the matter, Your Lordship, because they have issued an advertisement, Your Lordship. I will be pressing on the interim prior to participate in that.
My lord, I have an objection on that regard, that I have already been.
You're taking time. That's the whole problem. You have an objection, so you respond.
Lordship, no, it is the fix on my lord on 27/4, Lordship. I have to direct my lord that file the affidavit before my lord 6/4. So yesterday I have received the my lord that instruction. I'm going to file my lord next week, Lordship.
6/4.
That is no Lordship. May I kindly see the order dated 9/2.
Now 6/4, we place it on all the matters on.
27 it is fact, learned advocate general also asked to appear on that day, Lord.
On 27th, though?
Filling up of forms.
April.
Have they issued the advertisement?
Lordship,
What
That
is
is
the
an
last date for filing the application?
Annexure 5, that is probably
What is the last date for filing the application?
30, Lordship. 34 of the next month. It commences from 15th of this month, Your Lordship, already.
And even then, Lordship, kindly goes to that they did not challenge the my lord amendment rule, Lordship, in the pair for. Lordship, kindly see the pair portion also.
No, we never.
And my lord, that petitioner and the
Lordship, limited prayer is to allow this petitioners to participate in the process.
Not petition, additional applicable.
That we don't.
that they did not challenge the my
You
lord
have
that
not filed IA.
That is
No,
there
no,
in the
no.
prayer itself, in page
they did not
17.
file IL also.
Page 17, Your Lordship.
No, you have not even filed. made a
Lordship,
prayer.
page 17, Your Lordship, of
Of
the writ petition.
the petition,
I have a prayer in the writ petition itself, Your Lordship. At that point of time, there was no advertisement. But subsequently, during pendency of this writ petition, they have issued the advertisement as well.
Lordship, kindly see what they have been challenged.
But we are not doing. We can prepone the date.
Lordship, that can be.
Where is, by which order we have fixed a date?
19.
19/2, Lordship.
19/2. You are appearing at which matter?
Item number 22, Your Lordship. WPC 143.
143.
It was mentioned by me.
You are Mr. Mukherjee.
Lordship.
Mr. B.J. Mukherjee, learned advocate, appearing in WPC number 143 of 2026. Process for the interim relief of a direction to the respondents to permit them to apply against the advertisement which has been issued recently for filling up the posts of lot mandals. he submits that other connected matters are scheduled to be listed on 27th of April 2026. So in that case, he would have no time to prepare for the examination. He therefore prays for an early listing of all the cases. Acceding to his request, we direct that all these cases, namely 22, 23, and 25, we listed for consideration on
Lordship,
8th of April, or maybe 20th of April, maybe 21st of April.
in my understanding, Lordship, the other matters are not directly connected.
Just a minute, we will not do it. 21st of April.
21st of
Or
April.
should we only keep your matter on?
Lordship, second.
Only that matter.
Sixth, by sixth, they will be filing their affidavit.
All right.
After that.
So item number 22, Nasaika, this is the prayer. Let it be listed. Let this matter be listed. Acceding to his request, the item number 12, acceding his request, WPC number so is directed to be listed on 21st of April. By which time, the land council is waiting for the respondent number.
Lordship, respondent number, I appear on there 2, 3, 4, 6, and 7.
For this
I will sit down.
shall file their affidavits.
Not
Shall file their affidavits. Okay, shall file their.
By 6, I will file.
Let, item number 23. 23, 24, and 25. No, 23 and 25.
23, 24, 25 matters.
23, 24, and 25. Where adjournment slip has already been circulated, be listed for consideration on 21st of April.
Obligation.
Lordship, the interim.
All matter. Some matter. Same common. No entering.
Lordship, that may be considered on the next.
That we will. Otherwise, if
They have
we
a
can say
time
that
of
rejection rejected.
And even then, Lordship, PTC has also did not met in its case of a party.
Heard the court, we are not granting, we are not interested, we are inclined to write that the prayer for entering relief is rejected. But because he has decided to argue that on the next day, we will consider.
Lordship.
Item 26.
Come on to the list. We'll come to 26, I think the order of the list. Yes.
May I please? My lord, 1 hour ago, my lord, they filed their affidavit, my lord. I have received copy. My lord, we are not filing the affidavit in reply, my lord. So, my lord, matter will take for final disposal.
Mr. S. Chauhan, learned advocate for the appellant, seek some time to file the rejoinder affidavit by the next day. Let that be done. Let that be done on or before the next date. They notify it. 6 weeks.
15 May. Item 27.
So, check it. Let's check it. Yes. Yes.
Proceed, we went to our father along with one mediator and one of my well-wisher. Because my daughter's NEET exam is also ensuing on May. But my father is adamant. He's saying that we will go with the decision of the honorable court. This is pending. It
Who
is
appears for the father?
your lordship.
Who appears for the father?
So, please, okay, Lordship, appeal for respondent number
Where
2.
is the advocate who was?
Respondent number 2.
Where is she?
If the mediation pieces between the parties fail.
No, where is Ms. Chaudhary?
Sir, our one close relative died, she went to appear the funeral ceremony.
it appears that the name of Miss Chakravarti.
Respondent number 2 wants to appear before the honorable court.
Respondent number 2, yeah, why can't you speak loudly so that I hear?
Lordship, respondent number 2 wants to appear before the honorable court. So a time may be granted. Father, yes.
Every granting time next week after Bihu is okay.
Sorry, yes, after the assembly election.
After the assembly election.
Yes, so probably.
Ms. Chakravarti, we were about to dictate that since your name is not reflected in the constitution, so today you're not here. But now you're here.
Right.
After elections is 9th of April. After that, the court closes, so it has to go after Bihu. Again, a request has been made on behalf of respondent number 2 that in order to enable him to appear personally or through VC, a date and time be fixed. Considering this aspect of the matter, considering this request, the matter is listed for consideration. This matter is listed for consideration on 23rd of April at 2 p.m.
Take your Lordship. Have a nice day.
Item 28.
No, I appeal. This is the online. No, I have been filed for,
Just a minute. Yes, what do you have to say?
Well, my submission is that the application is not maintainable before this honorable court.
Why?
Well, the jurisdiction otherwise you'd like to.
Not necessary. You respond to this territorial jurisdiction argument, we will deal with it. The head office is in Silchar, which is in the state of Assam.
No, head office is at Delhi. Head office is at Delhi. The order was issued from Delhi. It was served on me in the state of Tripura. And that termination order is the cause of action for which I had to approach the tribunal. A tribunal is a common tribunal for all the 7 states. And therefore, my submission is that the jurisdiction would lie with the Honorable Tripura.
File your written response with respect to this.
Well, I have filed the IA. IA is by me only. I have filed the IA.
Yes.
I'll submit my reply to the IA. I see.
Here, Mr. Datta, learned senior advocate, has appeared on behalf of the respondent and has submitted that this court does not have the jurisdiction to entertain the present petition, notwithstanding the fact that the order impugned in the present petition has been passed by the Gauhati bench of the Central Administrative Tribunal, which is the bench which deals with all matters arising out of northeastern states. It has been submitted that the order impugned was passed at Delhi. At Delhi and was served on the respondent in Tripura where he had been in service. In that view of the matter, the jurisdiction would lie before the Tripura High Court, not before Gauhati. This argument has been raised by you have filed an IA?
Yes, ma'am.
What is this IA for?
IA is questioning the maintainability.
You have to file your counter affidavit and in that you have to take a plea that jurisdiction issue must be
Well,
decided.
if the IA is considered, then I need not traverse the merit of the matter.
That's a procedure which is unheard of.
But
I don't know how it is being entertained.
Well, I have sought
Who are you? How did you file IA here?
Well, I have filed
Whatever you file has to be an affidavit in opposition if you're challenging it.
Well, I have seen these sorts of applications are filed in various proceedings and the courts are entertaining it. There are instances.
Only Gauhati High Court.
No, there are instances even in
I can tell you about 3 courts that I have visited that have worked. It doesn't work like that. But anyway, we are treating your IA as okay. This argument has been raised by Mr. Datta in an interlocutory application filed in the present petition. So the aforementioned interlocutory application is treated as the affidavit in opposition, raising the jurisdiction issue, which is required to be adjudicated first before getting into the merits of the case. Mr. So-and-so, Mr. Mazumdar.
Yes.
Mr. Mazumdar and counsel for the Kendriya Vidyalaya Sangathan / petitioner seeks some time to respond, seeks some time to file the rejoinder petition. Let that be done by on or before the next date, re-notify after 5 weeks.
11 May.
Can it be a little earlier? Because it's a matter.
He has to file jurisdiction even challenge. Let's see, you are only during the period of probation, no?
That is true, Millard, but the tribunal's order is in my favor and I have been out of employment for so long.
Doesn't matter, so we will keep it sometimes in the last week of April, 27, 28, 29th, whichever.
28th of April.
28th of April.
Mother 20th of I have come.
27th in that case.
27.
7. Only 29th. If not in April.
29th of April. Therefore, we don't give this latitude to the advocates. We'll keep
Madam,
looking at the calendar. 29th.
Mother. Item 29.
This matter, we have received the paralyzed comment from 18th.
What is it?
That reply, my lord, was supposed to be filed, my lord, as indicated in the order. The instructions from the department has been received by me, my lord, on 18th. I pray for some time to file reply, my lord. Morning, my lord, I tried to mention, my lord.
Select the tainted, keep him out of the system. Don't kill the entire system, entire process. Anyway, file your response. Get Mr. Mr. H. Gupta, Leonard CTC, submits that he has received instructions and he shall be shortly filing the counter affidavit in this matter. For the aforesaid purpose, he seeks a short accommodation. Let this matter be listed for further consideration on. Then it goes to May.
Fine.
Sometimes those people.
4th May.
By which time the counter affidavit must be filed.
There was an interim order that may continue.
Interim order is the meanwhile shall fulfill. What was the interim order?
To go for fresh,
Then all this, anyway, please, wait.
Item 31.
Highly approved. Yes, Ms. Ghosh. You were sitting in the back when your case was about to be called. I will keep it Lordship elections. There's nobody to respond. What do you have to say? Have they read the sideways?
No, Lordship.
They have not.
Not this morning also I visited before coming to this post.
Did I ask Mr. Patniar or Mr. Nayak?
And the affidavit Nayak, and in fact, I have filed a rejoinder to the affidavit what they have filed, Lordship. And in fact, so I had filed an IA, Lordship, to implead PW.
Mr. Nayak, your lordship, the additional AG, your
Where
lordship.
is Mr. Nayak?
He's on legs, your lordship. However, we filed an affidavit, your lordship, whereby we have visited the site as well as some photographs also have been annexed, your lordship, that the work has been done.
Let's see.
Lordship, may I submit to that?
No, have you served her a copy?
Yes, your lordship.
Yes, I received that.
Okay. Have you
Based
filed
on
it
this,
also?
Yes,
I
your
have
lordship.
filed my
We filed on
rejoinder
18th of December, your lordship.
I have filed my rejoinder also, Lordship. And in my rejoinder, Lordship, I have taken Google
Ms.
photographs.
Ghosh, you are forcing the court. One of us will go one day in the evening to see whether affidavit by you or the affidavit by Mr. Nayak is correct.
And they have given the road photographs and it's at night. Night, there will be no traffic in that road, Lordship. And the students will go to.
After the elections, we will hear.
Yes,
Maybe
Lordship.
during that period, during the period that the court is closed, I might give a visit to that place incognito and see who is telling the truth.
My Google photographs with timings also, Lordship, is there, which I have filed in my rejoinder affidavit.
Let this matter come up for further consideration on your date. I think we keep it in May.
Yes, Lordship. Deeply blessed.
7 May.
Deeply.
Item 35.
In this matter, I pray for little accommodation today.
It's already taken a lot of time.
Yes, that's it. Mr. K. Gogoi and Mr. A. Somua, both are arguing a matter in court at court number 18.
As jointly prayed for on behalf of the parties, re-notify it in May.
19 May. Yeah, date reference. Item 33 and 34.
Yes. Yes, who appears?
Here in this case, also, there was a direction by the Honorable Court to add the part 2 of the judgment, Lordship. That is not there in the paper book, Lordship. I have flag marked that part in the record, TCR.
That's the sentence.
Sentence.
ठीक है, आप पास करिए. Don't take time and don't think that we are going to grant time. Death reference is not to be adjourned lightly. Yes.
There in this case, your Lordship will find at page 3, Lordship.
When you start arguing an appeal, there are two basic facts that you need to state before the court. The first is, what is this and who are the appellants? Here it is one. So the appellant is so-and-so, he has been convicted under section so-and-so, by judgment dated so-and-so, sentenced to so-and-so, by order dated so. These facts. Then, when was FIR lodged by whom? Name of the eyewitnesses. Thereafter, you say what is the number of the prosecution witness, the doctor, the IGO, if any forensic examination has been done, that you say. Then take us to the relevant section and we will ask you how to go about. So where are those facts? You must state that, no?
From the FIR, just I'm placing that accused number.
Don't place it from the FIR. First, give us the statistics. Figure.
In this case, FIR was lodged on 14/10/2020.
Conviction under which section?
Conviction under 6.
Appeal. I told you how the methodology. Nowhere in the country it's argued like this, that you start reading the FIR. No. We'll ask him, what do we want? Right?
In this case, conviction under section.
Now, let me ask you the questions. Conviction under which section?
302.
Only 302.
302.
Can we? 302 simplicity.
That part you will also find that page.
Charge was under section 120B, let me 302.
Charge was under section 302.
Take a note, no? Mr. Ahmed, I have been handling criminal cases, therefore I would expect better alacrity from the advocate.
I was informed that the sentence part is not there, so they may ask for time. That was.
Who can ask for time? The court has to grant you time. The court is not interested.
That I understand. Yeah, only 302. The charge framing is there, page 6, only 302. Charge was framed under section 302.
302.
302.
Okay. Conviction under section 302.
302.
Sentence to?
That date sentence.
Now, yeah, date.
Well,
Tell me the date of occurrence.
date of occurrence is not yet on the same day the affair was lost, 14/10/23. In 14.
Mr. Ahmed, can't be.
13/10. Okay.
The date of occurrence is 13/10.
13/10/23. Yes, sir.
Is preparation for the, you can't argue before this.
Actually, I missed my notes. That is the difficult. I'm sorry.
चलो देखते हैं कम से कम 3:30 will hear you if you are able to sustain.
No.
So date of occurrence is
13/10/23.
10/2023.
Yeah.
FIR lodged on the next day.
Next day 14/10/23.
14/10/2023.
Yes.
Lodged by whom?
Lost by lordship Pulok the Kumar Das.
Pulok Kumar, the matlab hai, am I asking for the name? Then we'll read it on our own. If I have to ask you questions every now and then, this is not the way that is argued. Then I ask the amicus. But I don't want to demoralize you. I don't mean to, to say, I'm asking who is the informant you say is the brother of the deceased or wife or whoever. You have to say something. No? Relationship is important.
Sister of the
I don't think so. No, I don't think so. The brother of the deceased has filed. उसके लिए उस दिन तो आप बहस कर रहे थे. I remember it of that day. The brother has filed a report. Lost by his PW?
His PW1.
Daily list for this item 1.
Nobody appeared. So awaiting the report regarding service of notice on response number 3 and 4. On response number 1 to 7. The matter is that
May? 18th May. 18th May. Item 2.
Who are to be noticed in this review?
Note 1, there were 144 in numbers. The employees.
Let notice be issued to the respondents number 12 on the steps being taken by the review petitioners, that's Union of India and others. Petitioners में कट्टे bracket करते हैं, Union of India and others on steps being taken by the petitioner within a period of 2 weeks. 3 weeks, both modes, returnable June.
May I pray for a paper publication, since they are large in numbers, we will publish in the
Paper publication substituted only after this. Your difficulty is not going to. So you can serve it through your whichever. Through your
8 June.
June.
Both them. 8 June.
Okay.
Both them.
Both them.